Hello again, I'm attorney Robert Flessis for Robbins & Lloyd Career Training Institute. This is part 2 of course 8. In this video, we're going to discuss the disbursement of earnest money. Let's get started. Unless you're licensed as a broker, you probably never had to deal with earnest money besides collecting a check and giving it to your supervising broker. The controlling legal authority is REEB 18.09. Remember, REEB stands for the Real Estate Examining Board. There are 3 parts of that administrative code that pertain to earnest money: the proper disbursement of earnest money, notification of disbursement, and withdrawal of commissions. The administrative code also cites a Wisconsin statute, 452.14 sub 3 sub I. The first section of this statute says that a firm that disperses trust funds from the firm's real estate trust account under any of the following circumstances shall not be deemed to have violated the statute. Well, what are the circumstances? Well, you're expected to do the following when earnest money is dispersed, and here they are. If an offer is rejected or it expires, or there's a withdrawal of the offer prior to binding acceptance, or for that matter, a lease, exchange agreement, or option, you're required to return the earnest money to the payor. That's the person who delivered it. The second rule under the statute states that if you have a written earnest money disbursement agreement that's signed by all of the parties that have an interest in the earnest money, then you disperse it to the payor. Did you also know that a closing statement is considered a written disbursement agreement? You learn something new with each video, don't you? The third disbursement rule is earnest money can be dispersed to a court having jurisdiction over an action disputing the disbursement, and that is a small claims court. The fourth way to be authorized to disperse earnest money is by the direction of a court order. Fifth, if there's a question as to whether the earnest money should be dispersed to any one party, you can rely on the good faith decision that an attorney provides to you if that attorney is not representing any of the parties to the transaction. That attorney must be a disinterested third party. The sixth and last authorized way to disperse is by the authorization that is granted in the offer to purchase. So you have 6 legal ways that you can rely upon to disperse earnest money. And if you're not sure, REEB 18.09 provides legal guidance. What happens if you don't follow these 6 guidelines? That's where the Wisconsin statute 452.14.3I penalties come into play. The statute states that the board may commence disciplinary proceedings on any matter under investigation of a licensee if you demonstrate incompetence to act as a broker or salesperson in a manner that violates protecting the interest of the public. Holding earnest money places you in the position of a fiduciary. It's not your money that you're holding. It belongs to someone else, and you're just holding it until something triggers the release of that money, and to whom? Think about this. If you're holding earnest money and there's a dispute, the state is actually protecting you by explicitly guiding you on the circumstances that absolutely provide protection for you. All you have to do is read the rules. It's like reading the instructions on putting together something you just bought. That's all you have to do. And if you don't follow the earnest money disbursement rules, then the REEB is going to be knocking at your door. If you do screw up, then after a hearing to obtain the facts and an adverse decision is issued against you, you've earned the label of incompetent. The context of that word in this setting doesn't mean you're unable to make decisions for yourself. It means you don't know what you're doing as a licensee, and you need to go back to school to learn how to be doing what you need to be doing. And that's where I come into the picture. An offer to purchase spells out earnest money disbursement terms at lines 67 through 77, and those terms follow the disbursement rules contained in REEB 18.09. What do those lines tell us? It states that if negotiations don't result in an accepted offer and earnest money is held by a firm, the money must be promptly dispersed. Now, that also means that the check must clear your bank before you disperse to the party who is entitled to receive that money. Further, the money is only paid to the person who actually paid it. Let me give you an example. Let's say that a young couple is buying a house and the parents of one of them writes the check for the earnest money. Buyers Joe Smith and his wife get the check from Joe's father and mother, and Joe gives it to his broker for deposit. The offer isn't accepted, and by the rule, the money needs to be returned. Well, who gets the money? Joe or Joe's parents? Well, that's an easy one. The check is written to Joe's parents, or Joe, because they're the ones who paid it in the first place. Good. What if you forgot who paid it and just wrote the check back to the buyer? You'd be in violation of the terms of the offer to purchase and be in violation of Wisconsin Statute 452.143I. You would be deemed incompetent. And the board requires you to wear a dunce cap for 1 year in public. Just kidding. Do you see how delivery of earnest money to the payer in the offer to purchase follows the first rule of the 6 in the REEB code? What else does the offer to purchase tell us about disbursement of earnest money? It says at closing, earnest money shall be dispersed according to the closing statement. What's next? If the deal doesn't close, and if there's a written disbursement agreement signed by all of the parties, you have to follow that agreement. That language also follows the language in the code. What else? If you don't have a disbursement agreement, which is usually a cancellation agreement and mutual release, which we discussed in the next video, then this is how it works. You must have delivered a written disbursement agreement to the firm holding the earnest money within 60 days after the closing date. If not, then the offer to purchase states that the holder of the earnest money can disperse as directed by an attorney who reviewed the transaction and doesn't represent the buyer or seller, or deposit the money with a court that would hear the dispute between all the parties to the offer, or do what a court directs you to do with the money, or do what the offer tells you to do with the money, or any other disbursement requirement allowed by law. That would be the rules set forth in the REEB code. And the holder of the earnest money doesn't have to absorb the costs when a dispute develops. The firm or holder can hire their own attorney to give them advice on how to disperse the money, which includes filing an interpleader action with the court. Well, what is an interpleader action, you may ask? It's a way for the holder of property, in this case earnest money, to initiate a lawsuit between two or more parties to the property. You're putting the parties who are knocking heads into a lawsuit to fight it out. For example, person A holds the earnest money and knows that the property is not his or hers, but the buyer and seller are both claiming that the money is theirs. So the holder of the earnest money sues both the buyer and the seller in this interpleader action. By doing that, the buyer and seller are now litigants, and the court decides who owns the money. As the holder, you're taking the problem and letting the court decide, not you. Now, this action can be commenced within 60 days after the closing was supposed to happen. None of the parties could agree during that 60-day period, so it's time to go to court, and that action is initiated by the holder of the earnest money. That's a good and final solution to take the problem out of your hands as the holder and drop it into the court's lap, because you can. One provision that helps the holder is that when the holder obtains the services of an attorney to direct the disbursement to the court, then the firm can collect their costs and any reasonable attorney's fees, not to exceed $250 million. No, $250 prior to the disbursement. Do you think that's enough money? Probably not, but at least it's something. Let's summarize this procedure. You must follow the rules set forth in REEB 18.05. If you don't, you're deemed what? Incompetent. When you're dealing with an offer to purchase, you must follow the terms set forth at lines 67 to 77 of the offer to be in compliance with the terms of the contract. In most transactions today, a title company is the holder of the earnest money, and they would have to follow the terms of the contract. If you're a licensee, then not only do you have to follow the terms of the contract, but you, as a licensee, must follow the code at REEB 18.05. Let's all say that together. That's a double whammy for a licensee. And what are the rules under the code again? You must disperse to the payer if the offer is rejected, it expires, or one party withdraws before acceptance. Second, you must follow the disbursement agreement if there is one, and that includes the closing statement if the deal closes and there's no resolution of the earnest money dispute. Next, you can disperse the money to a court, or you can follow a court order for disbursement, or follow the good faith decision of an attorney's advice. If the attorney doesn't represent any of the parties, or upon authorization granted in the contract, and which all else fails, the holder hires an attorney who may advise the holder to file an interpleader action to rid the holder of the problem. Got all of that? Good. Well, that's all, folks, for earnest money disbursement. In the next video, we're going to talk about a cancellation agreement and mutual release. That document is very important because it represents a written disbursement agreement like we talked about here. I'll see you in that video.